Hello everyone, I am Vijaya from Manu Law Classes, and today I'm going to be discussing with you the topic of legal GK for the month of April and May 2021. During the course of my session, I will be citing some important judgments that have been passed by various courts in India, as well as recent amendments. Before I start, let me inform you that our organization is starting with 1 year as well as 2-year courses for the CLAT aspirants. You may enroll today itself. We are also providing a 15-day free trial for these classes, and you can sign up by clicking on the link given in the description below. Moving on, let me start with the first judgment of the Supreme Court. The case is called Gautam Navlaka versus National Investigation Agency. This case is popularly known as the Bhima Koregaon case. In this, an appeal had been filed by Mr. Gautam Navlaka seeking default bail. His appeal was against the order of the Bombay High Court. In this, the primary bone of contention or the issue before the court was whether the 34-day period of house arrest that Gautam Navlaka had spent in detention, whether that shall be included for the purposes of counting his 90-day detention period for granting default bail under section 167 subclause 2 of CRPC. Now let me tell you what section 167 subclause 2 of CRPC states. Under this section, the magistrate is authorized to grant detention of an accused person for a maximum period of 90 days if the person is accused of an offense that is punishable with death, life imprisonment, or imprisonment for a term of more than 10 years. So in this case, the High Court had said that the unlawful custody or the term of unlawful custody that Gautam Navlaka had spent under house arrest, it is not to be included in counting his period of 90-day detention as prescribed under section 167 subclause 2, especially since his arrest as well as his detention was illegal. The Supreme Court, it agreed with the High Court's observation, and it said that since the order of the magistrate or the authorization of the magistrate to detain Gautam Navlaka was illegal, therefore the detention was illegal. So the house arrest custody cannot be construed as authorized custody within the meaning of section 167 subclause 2 of CRPC. Now, since the house arrest is not an authorized custody, therefore it will not be included while computing the 90-day detention period, which is required for the purposes of granting a default bail. Further, the Supreme Court also observed that habeas corpus petition, it can lie against a remand order only if 3 conditions have been satisfied. And those conditions are that the remand order was illegal, or the remand order had been passed in a mechanical manner, or there was a lack of jurisdiction. So unless these 3 conditions have been satisfied, a habeas corpus petition cannot lie against a remand order. Moving on to the next judgment, Dr. Jesri Laxmanrao versus the Chief Minister and others. This is a very significant judgment relating to the Maratha reservation in the state of Maharashtra. Now, let me give you a brief background of the reservation policy in India. Under the Constitution of India, Article 15, subclause 4 and Article 16, subclause 4, they empower the state to make special provisions for the advancement of socially and educationally backward classes of citizens and scheduled castes and scheduled tribes. Now, there was an important judgment that was passed regulating this reservation policy in India, which was Indira Sahani versus Union of India, also which is famously known as the Mandal judgment, Mandal Commission judgment. In this, the Supreme Court had ruled that the reservation in the state, it should not exceed the 50% ceiling limit. And in case the ceiling limit has to be raised by the state, there has to be extraordinary circumstances or extraordinary reasons to justify the extension of the ceiling limit beyond 50%. Now, coming back to the facts of the present case, the Maharashtra government, it passed the Maharashtra State Reservation for Socially and Educationally Backward Classes Act 2018, reserving 16% of seats for Maratha community in educational institutions as well as government jobs. Now, by virtue of this reservation granted to the Maratha community, the overall reservation limit in the state of Maharashtra exceeded the 50% ceiling limit that was laid down in the Indira Sahani case. Now, the state justified its stand or this act on the ground that extraordinary circumstances existed for passing of this act. The case was filed in Bombay High Court challenging the act. The Bombay High Court upheld the validity of the act. However, an appeal was filed in the Supreme Court against the judgment of the Bombay High Court, and the Supreme Court, by a Constitution 5-judge bench, it held that the reservation which was granted to the Maratha community was unconstitutional, violative of Article 14, and therefore void, and that there were no extraordinary circumstances that were there to grant reservation above 50% in the state. Moving on to the next judgment, the Chief Election Commissioner of India versus M.R. Vijaya Bhaskar. In this, an appeal had been filed in the Supreme Court by the Election Commission of India against the High Court of Madras's order, whereunder the High Court had made certain disparaging remarks against the Election Commission, attributing the responsibility for the recent COVID-19 surge in India on the Election Commission, saying that they had violated the COVID-19 safety protocols and measures during the elections. So therefore, a plea was filed against this order before the Supreme Court, whereby the Election Commission pleaded before the court to restrain the media from recording the court proceedings. However, the Supreme Court, it rejected this plea of the Election Commission, giving significance to open court hearings. And it said, the court observed, it said that citizens of India, they have a right to know about what happens in the courts, about what transpires in the judicial proceedings. And therefore, this freedom of speech and expression that has been granted to the media is a virtual extension of open courts, and it cannot be a cause of apprehension, but it is a celebration of our constitutional ethos. And therefore, open court hearings cannot be ruled out. The next judgment is Pardeep Singh and another versus State of Haryana. This judgment was passed by the Punjab and Haryana High Court. In this, the court said that live-in relationships, they are not prohibited under the law, and these relationships, they are entitled to equal protection of laws. The court said that every person has a right to formalize his relationship with his partner, either through marriage or they can adopt a non-formal approach of a live-in relationship. And this right of an individual, which is right to life and liberty granted under Article 21, it entitles a person to the full development of his potential by choosing a partner according to his choice. So this right cannot be denied to him. However, this ruling of the Punjab and Haryana High Court is in stark contrast to an earlier observation made by the same High Court, but by a different bench, in which the court had said that live-in relationships are not morally and socially acceptable by our society. The next judgment of the Supreme Court is PASL Wind Solutions Private Limited versus GE Power Conversion India Private Limited. This is a judgment of the Supreme Court which deals with the Arbitration and Conciliation Act of 1996. In this case, the court ruled that Indian parties, they are free to choose an arbitration seat outside India, and there is no bar under the Arbitration and Conciliation Act in choosing a foreign law as a law of contract between the parties. That means the parties can choose a foreign law as the law of contract which regulates them. However, if an award is passed by virtue of the arbitration, it would be deemed to be a foreign award and it would be enforceable in India under Part 2 of the Arbitration Act. Moving on to the next judgment. This is Lalithkumar Jain versus Insolvency and Bankruptcy Code of India. In this, the Supreme Court, it upheld the validity of the 15th November 2019 notification that was passed by the central government. The central government, by virtue of this notification, it had allowed the creditors to initiate insolvency proceedings even against the personal guarantors under the Insolvency and Bankruptcy Code. However, there were a lot of petitions that were filed against this notification before various high courts. The Supreme Court, it transferred all these petitions to itself on the government's request, and it decided the validity of this notification. The court said that this notification is legal and valid, and the creditors, they can initiate insolvency proceedings under the Insolvency and Bankruptcy Code of India, even against the personal guarantors as well as the corporate debtors. The court said that there was an intrinsic connection between the personal guarantors and the corporate debtors, and they both should be dealt with by a common forum, that is National Company Law Tribunal, by the same adjudicatory process. Therefore, by virtue of this judgment, the Supreme Court, it has held the personal guarantors also to be liable under the Insolvency and Bankruptcy Code of India. Moving on to the next judgment, that is Red Bull versus Bakewell Biscuits. This was a judgment that was passed by the Delhi High Court, whereby the Delhi High Court, it restrained the organization called Bakewell Biscuits from using the trademark of Red Bull, which was a red horse mark. The court stated that this trademark of Red Bull, it is already recorded in the list of well-known marks that is maintained by the trademark registry, and therefore Bakewell Biscuits cannot use this red horse mark in any of its products. Now let's go to the recent amendments that have been passed by the court, by the law. The first act that was amended is the Government of National Capital Territory of Delhi Amendment Act of 2021. The Government of National Capital Territory of Delhi Act 1991 had been enacted to supplement the provisions of the Constitution relating to the Legislative Assembly and the Council of Ministers of the Delhi government. Therefore, by this act, which was amended recently in 2021, primacy has been given to the Lieutenant Governor over the elected government. The act states very clearly that government of NCT of Delhi means the Lieutenant Governor of Delhi. This act, this amendment, it has given immense discretionary powers to the Lieutenant Governor, even in those matters where the Legislative Assembly of the state had power to make laws. So the elected government, it has to seek permission of the Lieutenant Governor before taking any action. By virtue of this amendment, the Legislative Assembly is barred from making any rules that concern the day-to-day administration of the state of Delhi. So all in all, we can say that this amendment, it has left the elected government of Delhi toothless, and it is against the spirit of federalism provided under the Constitution of India. Let's go to the next amendment. That is Insurance Amendment Act of 2021. This amendment has increased the foreign direct investment limit in the Indian insurance companies from the previous 49% to 74%, thereby accelerating growth and spurt in competition in the insurance sector. This amendment has also removed restrictions on ownership and control, and this amendment became effective on 1st of April 2021. The next amendment is the Juvenile Justice, Care and Protection of Child Amendment Act 2021. This act has been amended, and there have been certain provisions that have been, or changes that have been made. The first is that the act, it provided that all the offenses that were punishable between 3 to 7 years of imprisonment, they were earlier cognizable, that is, an arrest could be made without a warrant, and non-bailable. However, under the new amendment, all these offenses between 3 to 7 years, they have been made non-cognizable and non-bailable. Secondly, if a person who was residing outside India, under the act, if he wanted to adopt from a relative in India, then he had to obtain adoption orders from the court. But under the new amendment, he can obtain these adoption orders from the district magistrate itself. Thirdly, all offenses under this new act are to be tried in the children's court. Earlier, it was that all offenses relating to children, which were punishable with imprisonment of 7 years or more, they were tried by the children's court, and those offenses that were punishable with imprisonment of less than 7 years, they were tried by the court of judicial magistrate. But now they've been clubbed together, and all the offenses are now going to be tried by the children's court. With this, I am concluding my lecture. During the time of this pandemic, please wear your masks, maintain social distancing, stay safe, and stay strong. Thank you.